SJC-12546, Commonwealth v. Nathan Ernesto Lugo.
May it please the court, Katie Essington for the defendant Nathan Lugo. Mr. Lugo asked this court to overrule its prior decisions in Okoro and Brown and hold that these sentencing statutes for juveniles convicted of second-degree murder are unconstitutional, and that a Miller sentencing hearing is required before a juvenile defendant may be sentenced to life with parole in the Commonwealth.
And after the Miller hearing is done, if you prevail, what are the options of the judge?
Well, I understand this court is not in the business of rewriting statutes, but I would suggest that the sentencing judge then would have the option of a discretionary life with parole sentence at the high end and a term of years as an alternate sentence.
What do you do with the proportionality argument when we've consistently used the benchmark in these juvenile cases of murder?
I would suggest that the proportionality under Article 26 and the 8th Amendment requires that the sentence be proportional to not only the offense but to the juvenile. And that requires a consideration of individuals' particular qualities of that particular juvenile. And that you cannot, because of the mandatory nature of the sentence in Massachusetts as it currently exists, there's only one option for the sentencing judge, that is not a proportional sentence in every case. It could be proportional in some cases, but not without consideration of the individual Miller factors. In the Commonwealth today, we have a situation where juveniles convicted of first-degree murder are now entitled to Miller hearings because there is discretion in terms of setting the parole eligibility date by the judge. And we have a situation where juvenile defendants convicted of manslaughter are entitled to a Miller sentencing hearing because the judge has discretion in those sentences. But we have this class, which Mr. Lugo is part of, where convicted of second-degree murder, there is absolutely no discretion for the sentencing judge, and therefore no right to present the Miller factors.
Are you raising a concern that if you don't have the Miller factors raised, you just can't capture them for whenever the parole eligibility might be?
That's certainly part of the concern, is that the Miller factors are going to be relevant in the parole hearing down the road, and that it's very difficult for the juvenile 15 years later to try to recreate what his mental, emotional state and home life was like at that time. So it's part of the concern is certainly preservation of evidence, making a record. But I would also suggest that the court must have some discretion somewhere in order for this to be a meaningful Miller sentencing hearing.
And under what constitutional provision does the court have that discretion? Because the statute does not give the judge any discretion.
Well, my argument is that the statute is unconstitutional under Article 26 and under the 8th Amendment, and therefore this court must strike it down. And obviously the legislature at some point may choose to weigh in on this issue, but in the meantime, that the court should simply convert this from a mandatory life with parole sentence to a discretionary sentence with a term of years being an option.
I thought in your brief you said that you were not claiming it was cruel and unusual.
I don't believe that's what I said, or if I did, I didn't mean to say that. I think what I said was that I'm not arguing that the 15-year parole eligibility date is not proportional to the offense. It's the mandatory nature that does make it cruel and unusual and not proportional. of the upper end of the life with parole.
What has changed since Okoro?
I think since Okoro,
I know you're arguing we got it wrong, but has anything changed?
yes, I think the science, first of all, the neuroscience is more firmly settled than it was at the time of Okoro. Certainly, the Commonwealth does not cite any studies disputing the science. I think the recent science has suggested that brain maturity happens even later than we originally thought, and maybe even later than this court considered in Okoro, that brain maturity does not occur until mid-20s, I think. And so we have more firmly settled science, and I think we also have a movement in the law nationally, away from this idea of mandatory sentencing for juveniles, particularly in homicide cases. And I realize that Okoro is not that old, but I do think, given that this court in Okoro indicated that it would be inclined to reconsider based on advancements in science, based on changes in the law, I think that both of those things have happened in the intervening years.
So if you prevail, the judge has the hearing, and then what type of sentence may the judge impose? Probation?
I think that this court has set 15 years for parole eligibility. I think that would be the sort of the floor, and then up to and including life with parole if the judge finds that's an appropriate sentence. So I think somewhere between 15 and life with parole. And again, obviously the legislature can come in and change that if it does not agree with those parameters, but it's the mandatory nature of this that makes it unconstitutional.
Legislature has already spoken.
Well, not recently, and not on second-degree murder. I don't think that has been changed since shortly after Miller was decided.
Well, didn't they revisit the issue of and say that for juveniles, although for an adult, the parole eligibility could be up to 25 years for second degree. For juveniles, it's only 15 years. So didn't they relatively recently revisit that issue and say 15 years is the appropriate amount of time for parole eligibility?
Well, I think we can debate what's recent, but I think that they have more recently revisited some of the other statutes and set the parole eligibility for instance, for first degree for juveniles from 20 to 30 years, but haven't in the last few years taken a look at the second degree murder statutes.
So what I hear you saying is that we should eliminate the mandatory minimum of life for second degree and transform it to essentially a 15 years to life.
That's correct, Your Honor. And again, the legislature would be free to come in and change that at any point.
So you're not saying that the sentencing judge here, there was an error of law or abuse of discretion. You're just saying that what you are saying is that this is unconstitutional.
That's part of what I'm saying. I do think there was an error of law in terms of the judge. Certainly the judge was required to follow Okoro and had no choice about that. But I do think the judge erred in denying counsel's motion to continue the sentencing hearing in this case for the reason that Mr. Lugo was entitled to make a record, to present this evidence that will be relevant down the line at his parole hearing, that he was entitled to present these Miller factors in a somewhat contemporaneous setting.
Even if there's no second indictment?
Yes, I think that he has a right to present the Miller factors and when they are fresh, that he should not have to wait 15 years to present mitigating evidence about his home life or his emotional state or the influences of peer pressure and all those factors discussed in Miller.
And is your view that you're entitled to a Miller hearing even if we conclude that Okoro is good law?
Yes. I think that it would be a strange exercise, and but I do think there is value in a due process right for the defendant to be able to marshal this evidence when it is most readily available to him.
You can't marshal it without the adversarial process. Why can't the defendant, through counsel and through experts, marshal that evidence? I understand why it's important to capture it. It's going to be important 15 or so years later. But why does it have to be through an adversarial process? I'm not even sure what that would look like. We're going to have Superior Court judges take 3 days to have a hearing over an issue they're not going to adjudicate?
Well, I agree that would be a very strange process indeed, and it is because of that I think that the court must find that the statute is unconstitutional and give the judge some discretion, because I agree it would be a strange exercise to have a lengthy hearing and then have the judge not have the ability to make any kind of decision at the end of that hearing. But, you know, this court has extended due process rights to second-degree juvenile defendants in Dyachenko too, such as the ability to have counsel at a parole hearing, the ability to retain an expert. But I think it's going to be very difficult to give meaning to those rights. I think you have to have a contemporaneous sentencing hearing, because I think it's very difficult for an expert who's hired, say, by counsel for the purpose of the parole hearing to then try to recreate what the juvenile's life and cognitive development was like 15 years ago at the time he committed the crime. That seems like it would be a very difficult task for any expert.
Why, going to Justice Lowy's point, why can't the defense counsel simply depose the expert as opposed to having the judge there? It sounds as if the judge is simply presiding over a deposition if the judge is not going to have any leeway in terms of what to do.
Well, I'm not sure there would be much incentive for counsel to sort of marshal and preserve that evidence for use 15 years later. And there was certainly wouldn't be any reason for it to be tested in the adversarial process. I mean, the Commonwealth would not be in a position to sort of refute that evidence and have experts cross-examined, et cetera. I just think that would be inadequate and probably wouldn't occur in a lot of cases due to the expense of that and the sort of futile nature of that, where this evidence is really only going to be relevant 15 years from now, when counsel may no longer, probably will no longer be involved in the case, and it's going to be a different branch of government that's going to be looking at this evidence, the executive branch. So I certainly think it makes more sense. The Constitution requires the court to look at the individual as an individual, and to allow him to present evidence of mitigation when it's most available to him. And I do think that while this court could find that the hearing is required even if the statute is constitutional, again, that would be a very strange exercise and wouldn't make much sense from the trial judge's perspective, certainly.
It seems a somewhat strange argument to say it's really important that you have this hearing, and in order to have the hearing have any consequence, we need to give it consequence by declaring unconstitutional the mandatory minimum of life.
Well, I don't think it is strange. I think that it's what Article 26 requires, that Miller really changed the focus to not just the offense, but to the specific characteristics of the juvenile. And I think that there have been lots of courts around the country and legislatures that have interpreted Miller's language broadly and read it as a requirement that this individualized sentencing hearing take place at the time of sentencing and not 15 years later at a parole hearing. I do want to turn briefly to the instructional issues in the case. Mr. Lugo contends that the trial judge erred in not giving an accident instruction and an involuntary manslaughter instruction, or instructing the jury that accident negates malice for the purpose of second-degree murder. The issue was fairly raised by the evidence, and in closing argument.
The defendant didn't testify, right?
That's correct.
All right, so the accident, as I read your brief, is premised upon the ballistician's cross-examination where he says the single action on the revolver made it somewhat of a hair trigger, right?
Partially. I would say that and the absence of any evidence that Mr. Lugo aimed at the victim.
Shot him in the chest.
Well,
in a moving car. So he's backing out. He's got the interloper stuck in the car. He points the gun and shoots him in the chest.
well, I don't respectfully disagree about the pointing at the victim. I think that
The gun,
Thames.
did the gun not have to point at him?
I think Thames testified that he sees the gun come out followed by a flash. I don't think there's really any evidence or testimony that he takes a specific aim. This is all happening very quickly.
What's accidental about someone pulling a revolver out of a hoodie, pointing it at someone they don't want in their car and shooting them in the chest? I don't get the accident part of that.
Well, I think there's two possible ways to interpret accident as the case is discussed. Whether it was an intentional discharge. Obviously, there's some case law that says even if it's not an intentional discharge, that's still involuntary manslaughter. But
That's different than wanton and reckless. But I mean, usually in an accident, in a shooting case, there's testimony, and that's why I asked you in the beginning. There's usually testimony that the gun just went off. We were wrestling with the gun just goes off. Here, there's no basis for that apart from this hair trigger issue, right?
Well, I would cite sort of the absence of testimony that either that this was planned or that there was a cocking of the gun prior to the discharge, or any testimony.
Doesn't it have to be cocked to be single action?
The testimony from the expert was that it did have to be cocked, but it could be cocked a day before, a week before. It could just stay that way. And so there was certainly no evidence that occurred just prior to the discharge.
Okay, thank you. I think your time is up.
Thank you.
Good morning. May it please the court, Stephanie Martin Glennon on behalf of the Commonwealth. We are asking this court to affirm the defendant's 5 convictions, which include the armed robbery and second-degree murder of 21-year-old Kyle McManus in 2011. He was sentenced not pre-Miller, years post-Miller, post-Diatchenko 1, and post-Okora to what he agreed was the required mandatory minimum statutory sentence, in effect then, of 15 years of life with the possibility of parole in 15 years. And as this court has held, you don't take the life sentence in isolation from the parole eligibility. It is precisely the parole eligibility that renders the life sentence constitutional and sets up a clear separation of powers here, which I would suggest in no sense would require a trial court at sentencing to become some sort of stenographic operation and impose that burden, that unnecessary burden on the trial court to hold a Miller hearing where, and I'll get to this, where the defendant does not ask for it and it cannot avail him. It can only harm him, I would suggest. When, as defense counsel has just said, the results of such of a hearing will only be relevant 15 years from now. I think that itself defeats the claim that there is something unconstitutional about this. This defendant, I think it's very important to stress that this defendant was given not just the benefit of Okora, the controlling decision of this court in Okora, although it's not insignificant that a trial judge does not have the discretion to ignore a controlling ruling of this court. The trial judge has to impose a sentence, and I'll here quote this court's decision in Renderos. The trial judge must impose a sentence within the limits provided by the statutes under which the defendant is convicted. He unquestionably did this here. The defendant concedes Okoro was directly controlling, and he agreed to the sentence. But at every stage of these proceedings, this defendant was given the full measure of all defendants, of all juvenile homicide offenders, whether or not he in particular would have exhibited any of the factors which Miller would have deemed potentially mitigating. That is, even at indictment, this defendant was given the benefit, the retroactive application of this court's prospective decision in Walzak, and he was reindicted. There was a new grand jury presentation. He was reindicted for first-degree murder and these other egregious offenses, including armed robbery. When it came to sentencing, it's important to realize that this defendant was unlike Okoro, not only in that Okoro was 15 years old and had a horrific background from which he could not have extricated himself. This defendant was different, very different from Okoro in the factual sense that this defendant was being sentenced for other egregious crimes, including life felony armed robbery. And as to that, I just want to point out that a normal, common sense juror listening to these instructions would have heard the trial judge say this, not a lapse of the tongue so much as I think a choice of one word that may greatly have benefited this defendant and plausibly suggests that the jury also compromised on a second-degree murder verdict in light of this. And that is, and this is at volume 11, page 25. I'm sorry, volume 9, page 169. As the trial judge here was leading from his instructions to the jury about the murder offenses, he informed the jurors that they were then to consider a separate indictment, a separate charge of armed robbery, and he instructed them that that, quote, requires a life sentence as a maximum punishment, not permits or allows. So it's certainly possible and I think plausible that going into their deliberations, knowing that this armed robbery, additional separate armed robbery conviction would be before them, the jury may have been under the misimpression that this then 21-year-old defendant they saw in front of them at trial was going to receive a required life sentence on an armed robbery conviction alone. And I bring this up because the defendant in his brief suggests that some positive factual conclusion ought to be drawn in his benefit because he wasn't convicted of first-degree murder. I don't think that's the case at all. In fact, his armed robbery conviction itself indicates otherwise, but I think that could easily explicate why he wasn't convicted, why he was convicted of second as opposed to first-degree murder. This is particularly important in answering your question, I would suggest, Your Honor, as to what would be the effect if this were to be sent back down to Judge Connors for a Miller hearing that the defendant didn't request at sentencing, when he certainly was aware of Miller and its progeny and could have asked for that kind of sentencing, that kind of hearing, had he deemed it wise to do so. Instead, what we had here was trial counsel who availed himself of a traditional sentencing hearing on traditional sentencing factors. And although the trial judge certainly wasn't required to be clairvoyant, I would suggest that here he was. Because in this case, the defendant got not only the benefit of this minimum, still nationwide minimum parole eligibility date on a murder sentence as a juvenile offender, but he also got the maximum benefits I would suggest that this court would not even create until 2 years later. This was a 2015 sentence that this court created years later in Perez 1 and just very recently in Perez 2. That is, The trial judge had discretionary sentencing available to him on all these additional serious, profoundly serious additional offenses, including the armed robbery of the murder victim of Kyle McManus. And as to all those sentences under Perez, were he resentenced today under Perez, under controlling law, the only thing that could change is the defendant's sentence could go up. So what the trial judge did here was he explicitly structured an entire sentencing structure based solely on the defendant's age. He didn't have to show any Miller factors that mitigated his life or his heinous crimes. The trial judge gave him the maximum benefit here. He said explicitly, and this is at volume 11, page 25, the trial judge said he was sentenced, he was designing this entire coherent sentencing structure to maintain the minimum parole eligibility date of 15 years, the constitutional proportional parole eligibility date the defendant had for a second-degree murder alone. So he got all these future benefits of this court's subsequent sentencing decisions when there are aggregate terms of years available, but he got none of the risks, which were profound. And that is that he could have, that at a Miller hearing, at which the Commonwealth most certainly would have had a right to be heard, at minimum, at a Miller hearing, the Commonwealth could have argued the nature of his crimes is a given. That's extraordinary in a bad way for him at sentencing. The Commonwealth also would have had an opportunity only to argue for an upward adjustment of the sentence. And the trial judge only would have had the power to find an upward adjustment, not a downward adjustment.
So if the defendant here had said, Your Honor, I know that you have no choice but to impose life with the possibility of parole, but you do have discretion as to what to do with regard to the armed robbery, so I asked for a Miller hearing with regard not to the murder charge, but with regard to the other convictions. Would the defendant be entitled to that hearing?
I think that's exactly how the sentencing proceeding. The defendant very explicitly said, Your Honor, I'm aware you have no discretion. There is, quote, no leeway in the second-degree murder sentence. Has to be life with the possibility of parole in 15 years. Counsel even put on the record, I understand, Your Honor, doesn't have any discretion with regard to parole eligibility on that either. So now let's go on to my individualized traditional hearing on the other crimes, and then argued the traditional factors which apparently existed and which favored him under traditional sentencing but not on Miller,
And if
the supportive family.
If the defendant had said, Your Honor, I wish to call an expert with regard to my client's psychological state or the effect of being a juvenile on it, I would wish to call a particular expert, would he be entitled to do that?
Well, that's not what he asked for.
Right, I know that.
But
I know that.
had he
I'm
asked
just trying to
to
figure out what is the entitlement to a Miller
Had he
hearing.
asked to present an expert, then, I mean, at that stage, given that the defendant had actually had a leading expert on juvenile brain development since well before trial, sentencing was no surprise. He had every opportunity all along the way, and he may well have preserved any helpful information that expert had for future use or for use then, but he didn't submit it. All he did was at that very late stage sort of muse that conditionally, were the trial judge to impose a sentence in excess of the constitutional mandatory minimum that was contemplated. And this, he actually made a request that went only to the armed robbery conviction because that, again, could have been a life felony. And what trial counsel said at the time was, you know, should the trial court then exceed the parole eligibility or come close to the line of the parole eligibility you've already, in effect, given him on the second-degree murder, then I might want to submit a memorandum. Then I might want to submit an affidavit. He understandably waived and abandoned that when he got the sentence that he did because it couldn't possibly have been more favorable to him.
But just to make clear for cases, future cases, if the judge has no intention on a second indictment of setting a minimum sentence, higher than 15 years, there's absolutely no reason for him to have a Miller hearing.
Exactly. The only predicate for a Miller hearing, as this court has held as recently as weeks ago in Lutskov, is that is the exceeding of the presumptively constitutional minimum mandatory sentence of 15-year parole eligibility. Otherwise, there is absolutely no reason and no right to a Miller hearing. I guess I want to revisit, because I don't want to risk misstating what I think is the fundamental misconception of seeking a Miller hearing at this stage and in these circumstances. And it's not simply that it's a separation of powers issue, because it is that too. But I think the core of a Miller hearing where there is an entitlement to it, the core of the entire assessment that goes on in a Miller hearing, and the reason why Miller held that life sentences without, or life equivalents without the possibility of parole ever, are unconstitutional is because a trial judge at the outset at sentencing isn't a parole board 15 hence. It isn't another board. A trial judge at the outset with the information available at sentencing, because and expressly because of the defendant's youth, he's considered part of a class of people. He may not be one of them. He may well not be rehabilitatable, but he's given all the constitutional advantages of being a juvenile, in this case 3 months under 18. If he had been a day under 18, he would have gotten the same advantage. And that is that because of his youth, because juveniles in general as a class are considered more amenable to the possibility of rehabilitation at the outset, a trial judge can't make a determination, can't fairly make a determination that a given member of that class, that the given offender before him will never be suitable for release during his life. But there's another side to that coin. For the same reason, a trial judge, at the time he imposes sentence or she imposes sentence, cannot possibly have the information to know that a given offender who's being sentenced for a heinous crime like murder will be rehabilitatable, will take advantage of the programs available to him as a juvenile but not an adult while he's incarcerated, that he will be ever reformed and rehabilitated as he matures, let alone that he will be at a certain age. And that's why it's simply not for the trial court